Hey guys, so I am Shagun Srivastava, and today we will discuss the topic the doctrines under Indian Constitution. So first of all, that what are doctrines? Doctrines are basically the theories, the principle, the tenets of law that are usually applied by courts of law. The doctrines have been developed by judiciary while interpreting the judgments of the cases. It basically acts as a guideline for deciding a case law, which gives a logical and a reasonable impact in the form of judgment. So several doctrines which have been applied till date have been explained in this video. Starting with a very basic doctrine that is very highlighted, that is doctrine of basic structure, according to which the parliament cannot alter the soul of Indian constitution. The very basic feature that is granted by our constitution, it cannot be damaged. So let us know that what are the basic features, that what are the criteria on which the basic structure is being developed. So the federal character of the constitution, secular character, separation of power, individual freedom, supremacy of constitution, sovereignty of India, rule of law, parliamentary system, etc. are the basic structure of constitution which cannot be altered by any way. So the case laws involved in the evolution of this doctrine starts with Shankari Prasad Singh versus Union of India, in which Supreme Court ruled that power of Parliament to amend the provision under Article 368 also includes the power to amend fundamental rights. Then comes next case, that is Sachin Singh versus State of Rajasthan, in which Supreme Court held that when the question regarding the amendment for constitutional provision arises, then the power in question can be exercised on all the provisions contained in. So coming to Golaknath case, that is in which the judgment was given that fundamental rights can be amended, and Article 368 provides a procedure for amending the constitution, but it does not confer the power on Parliament to amend the constitution. Then comes the leading case of Keshav Nanda Bharti case, which finally decided that amendments can be made, but the very basic structure, the very soul of the constitution should not be disturbed of Indian constitution. So coming to next doctrine, that is Doctrine of Eclipse. It has been given under Article 13 Clause 1 of Indian Constitution, that says that it does not apply to post-constitutional laws. So what this doctrine says? It says that when any law or act infringes any fundamental right, then that fundamental right overshadows a law. That makes that law enforceable, but it is not completely dead, but it is overshadowed. The inconsistency of the violative provision can be removed by the process of amendment. So this was the concept of Doctrine of Eclipse. Judicial review has played a vital role in establishing a Doctrine of Eclipse. Coming to the case law, that is P. Rathiram versus Union of India, in which the constitutional validity of Section 309 was challenged. And it said that 309 was violative of Article 19 as well as Article 21 also. So the Gyan Court judgment, so the section was violative of Article 21, which also gave the right not to live. Coming to Gyan Kaur versus State of Punjab, so this was held to be an invalid finding in this case. Thus, in essence, the Rathiram case had eclipsed Section 309 with fundamental right, which got removed by this very judgment, that is Gyan Kaur judgment. Coming to next doctrine, that is Doctrine of Pith and Substance. So what does Pith and Substance means? It means the true nature and substance. So the origin of this doctrines was founded by Canada, and it was introduced in the case of Cushing versus Depute in the year 1890. So this doctrine came to India by the Article 246 of the Constitution, and it simply states that if the substance of legislation falls within the legislature's legal power, the legislation does not become unconstitutional just because it gives effect to an issue beyond its area of authority. So the very essence of the act is seen. The Constitution has divided the power of legislature between centre and state by 7 schedules. So the Privy Council applied this doctrine in the case of Praful Kumar Mukherjee versus Bank of Khulna, in which it was held that the validity of legislation, that is impugned legislation, stated that Bengal Money Lender Act was in pith and substance, which was the law relating to money lenders and money lending, that was the subject of centre as well as state. Coming to the case of State of Bombay versus F.N. Balsara, in which Bombay Prohibition Act was challenged on the ground that it accidentally encroaches upon the import and export of the liquor across the custom frontier. That was the subject of central list. So the court, while upholding the legislation, declared that act was in pith and substance. It means that the true nature and essence was there, which involved the subject, even though it accidentally encroached upon the central subjects also. Next doctrine in the line is Doctrine of Colorable legislation. So it says that what cannot be done directly should not also be done indirectly. So this doctrine comes into picture when the question arises regarding the challenged statute, that it is within the jurisdiction or not. This doctrine verifies the competency of legislature to act on a challenged law. Under the Constitution of India, the jurisdiction for union and state has been conferred regarding subject matter of legislation. The lists have been given that what are the jurisdiction under which union and state government have to function. And Article 246 also demarcates the legislative jurisdiction of the parliament. So the Supreme Court, in the case of KC Gajapati Narayan versus State of Odisha, has outlined the meaning and scope of this very doctrine, as well as in R.S. Joshi versus Ajit Mills, court held that the jurisdiction of colorable legislation or fraud on legislative jurisdiction means that the legislature is incompetent to enact a particular law. Hence, this is the very concept of colorable legislation. The next doctrine is doctrine of harmonious construction. So basically, this doctrine is considered as the rule of thumb for the rule of interpretation. So whenever there is conflict arise between two or more enactments or provisions of a statute, the statute should be interpreted as in harmony. The principle of this doctrine has been highlighted in the case of Sri Shankari Prasad versus Union of India, in which the conflict arose between Part 3 and Part 4 of the Constitution, and it was the subject matter of the case. So the court, using harmonious construction, held that fundamental rights are conferred against the state, and it can be abrogated in special circumstances, and the process of amendment can be made. So the doctrine rests in the maxims that which means the general things do not go against special things, and the special things do not go against the general things. So both have been complemented together. The fundamental right has its importance, and the directive principles also have its importance. So the harmonious construction has to be made between the two. So the next doctrine in the row is doctrine of ancillary and incidental powers. So here the powers signifies the expression of those powers which are expressly conferred on the legislature. See, the legislature body exercises power to legislate on a particular matter, and they have the power to legislate on such other matters also which are related to that very subject matter. See, for example, if any state wants to impose any liquor ban, and you know that alcohol is the subject matter of state list under 7th schedule. So what state will do, it will empower to prohibit production, consumption, selling, buying within the state. But the procurement, the interstate trading is the subject of union list. But due to this very doctrine, the state becomes impliedly empowered to legislate on this very aspect also, as without banning its import and export, the total prohibition of the alcohol is not possible. So here the topic of related powers is involved. For example, in the case of Praful Kumar Mukherjee versus the Bank of Commerce, it was held that matter which state legislature deals may affect any item in the union list, and matter should be put in appropriate list according to its true nature and spirit. So this doctrine has its relation with the doctrine of pith and substance, which we have studied earlier. So this was the doctrine. Coming to next doctrine, that is doctrine of territorial nexus. So according to this doctrine, if any law is made by state legislature, so it is applicable in India only, except for the special granting of permission for sufficient nexus between the state and the object. It simply states that if any law is being made in India, it will not go beyond the jurisdiction of Indian territory. The authority of this doctrine has been granted by Article 245, which states that the Parliament has jurisdiction to make laws for extraterritorial operations. Means in certain special circumstances, Parliament can apply its law for extraterritorial operations as well. The state legislature also has jurisdiction to make law for the whole or any part of the state. Hence, it can be seen that the territorial nexus is divided between union and state list. Coming to the case Wallace Brothers and Company Limited versus Commissioner of Income. In this case, what happened? A company was registered and incorporated, which was carrying out its business in India. The firm made heavy profits in the accounting year. The income tax authority, they sought to levy a tax upon the company. The income tax authority was challenged by the respondent, but the Privy Council held that the tax was valid. So why the tax was valid? Because the major part of that income was extracted from British India, which was a sufficient ground to establish a ground for territorial nexus. So here the concept of territorial nexus was built up. Coming to doctrine of lashes. So this doctrine is basically used by the courts when a person is said to be liable for doctrine of lashes when he comes to the court for their rights after a reasonable delay from their part. So basically, this doctrine helps the defendant to put his reasons for delay, and it shifts the burden of proof upon the petitioner. Here, the doctrine of lashes explain that an unreasonable delay cannot be justified. The court will see into the matter and the facts of cases and find possible reasons for the delay in filing a lawsuit. Basically, it helps the person who is aware of their rights, and it points out to the person who is careless in filing a suit in correct time. Now, in the case of Haryana State Handloom versus Jan School Society, what happened? That in this case, the respondent they claimed that they have waited for some years and for the order to come. So the court said that respondent did not need to wait for some years to challenge the order for writ petition. So the respondent waited to challenge the ground because of an ulterior motive. So court said that doctrine of lashes works on a reasonable ground, and here no reasonable ground is seen for the delay, so party was not justified to claim the damages. Coming upon the doctrine of waiver. So waiver, what does it mean? It explains that person is the best judge of his own interest, and it gives full knowledge to him that he should decide for that what he should decide for himself. So in Indian perspective, a person has full authority to waive off his rights, which has arisen from any of the contract or document. So this doctrine is found on the principle of justice and reason. Fundamental rights are a part of constitutional right, and thus it cannot be waived off by an individual. These are the rights which are made for the welfare of the society, and if they are waived off according to intention knowledge of the individual, it will create a lot of mess and confusion in the society, and it will lead to a aggression by a general public. Hence, doctrine of waiver, it keeps a discretionary power on an individual and keeps a balanced check for the person who is in the right of exercising that power which is granted by the constitution. In the case of Jashwant Singh Mathura Singh versus Ahmedabad Municipal Corporation, the court held that person has the right to waive a legal right or any privilege that has been bestowed upon him. So these were the important doctrines which we have discussed above. So as a conclusion, I would say that doctrines are the beliefs and basically the power often held by authorities like courts, which have played a vital role in implementing decisions by the judiciary and in interpreting the law, which while giving effects to judgment. See, when a court issues a decision by applying a method, it creates a doctrine that can be used for future. So doctrine acts as a procedural step for determining the judgments in some legal matters which are commonly termed as precedent. So this was all. Thank you for watching the video, and please like, share and subscribe Law Minds for such more informative videos.